If you or someone in your family is waiting on a green card through a family-based petition, and you haven't looked at the actual numbers behind your wait time lately, what you're about to hear in the next few minutes could completely change how you're planning your future. Because right now, in 2026, the gap between what people think their timeline looks like and what the Visa Bulletin is actually showing is wider than it has been in years. And that gap is costing families months, sometimes years, of unnecessary confusion, missed opportunities, and in some cases, serious legal mistakes. This is not a scare video. This is a breakdown. Stay with me for the next 12 minutes because by the end of this, you're going to understand exactly where F1, F2A, F3, and F4 categories stand right now, what's driving these timelines, and what you can actually do about it. My name is Raymond Crivello. I'm a senior immigration analyst and consultant, and on this channel I break down complex immigration developments into clear, fact-based analysis you can actually understand. Whether it's a Visa Bulletin update, a USCIS policy shift, or a change in regulatory priorities, my job is to cut through the noise and give you something you can work with. Before we go any further, I want to be clear. I am not your attorney, and this content is for educational and informational purposes only. Always consult with a licensed immigration attorney about your specific situation. Every case is different, and nothing I say here constitutes legal advice. Now, let's talk about what's really happening with family green card wait times in 2026. The Visa Bulletin is published monthly by the U.S. Department of State. It controls when a family-based green card applicant can move forward in the process based on their priority date, which is the date USCIS officially received the underlying petition. The further back your priority date is, the longer you've been waiting in line. There are two charts that matter. Chart A, called Dates for Filing, and Chart B, called Final Action Dates. Chart B is the one that determines when you can actually be approved for your green card. And right now, for millions of people in the family preference categories, Chart B tells a very difficult story. Let me walk you through each category one by one, because the differences are significant and they matter enormously depending on where you are in this process. Starting with F1, unmarried sons and daughters of U.S. citizens who are 21 years of age or older. This category includes a significant number of applicants from countries like Mexico, the Philippines, China, and India, where demand historically outpaces the annual visa supply. As of the 2026 Visa Bulletins, F1 priority dates for most countries are moving, but slowly. For countries like Mexico, the final action date is running well over 20 years behind the current date. Let that sink in for a moment. An unmarried son or daughter of a U.S. citizen from Mexico who had a petition filed on their behalf recently could be waiting 2 decades before they can even apply for a green card. For the Philippines, the situation is similarly difficult, with final action dates lagging by 15 years or more. For all other countries, meaning most of the world, F1 dates are moving at a pace that suggests waits of several years, even for newer filers. But here's where this becomes critical. Many F1 applicants, and even some of their U.S. citizen parents, are not fully tracking the difference between petition approval and visa availability. USCIS approving the I-130 petition is step 1. That just gets you in line. It does not mean a visa is available. It does not mean you can file for adjustment of status or proceed with consular processing immediately. The wait begins after approval, and for high-demand countries, that wait is generational. Now let's move to F2A. Spouses and unmarried children under 21 of lawful permanent residents, meaning green card holders. This is arguably the most emotionally sensitive category because we are talking about spouses separated from each other and young children separated from a parent. The good news, and there is some, is that F2A has historically moved faster than other family preference categories. In recent years, F2A has often been current or near current for most countries, meaning applicants could move forward without a long wait. However, 2026 has introduced some turbulence. Demand in F2A has increased, partly because the overall number of green card holders in the U.S. has grown, and partly because processing timelines at USCIS have extended significantly for adjustment of status cases. The practical result is that even when visa numbers are technically available, the time from filing I-485 to receiving a decision has stretched. For countries like Mexico and the Philippines, F2A final action dates have shown retrogression in certain months, meaning the date moved backward, which can temporarily halt an applicant's ability to complete the process. If you are an LPR with a spouse or child in this category, this retrogression risk is something your attorney should be actively monitoring for you. This is what many green card applicants are misunderstanding. A retrogression does not cancel your case, it pauses forward movement. But if you are not tracking the bulletin monthly, you can miss a filing window, and missing a filing window has consequences. Moving to F3, married sons and daughters of U.S. citizens, regardless of age. This is one of the most backlogged categories across the board, and 2026 has not brought relief. The annual numerical limit on F3 visas is relatively modest compared to demand, and the category serves a population that has been filing and waiting for a very long time. For most countries, final action dates in F3 are running 10 to 15 years behind present day. For Mexico and the Philippines, the wait is dramatically longer. Some current final action dates in these countries for F3 reflect priority dates from the late 1990s and early 2000s. That is not a typo. There are individuals whose I-130 petitions were approved more than 20 years ago who are still waiting for a visa number to become available under F3. The reason for this is straightforward from a policy standpoint. Congress set annual numerical limits on each preference category under the Immigration and Nationality Act, the INA. The State Department allocates visas within those limits. When demand from a particular country exceeds the per-country cap in a given year, the excess rolls over, not forward, and the line extends. This is not a new problem. It is a structural feature of the current immigration system that Congress has debated but not fundamentally changed. There's one detail most people are missing here. Marriage actually moves a petitioner's child or adult child from one category to another, and not in a beneficial direction. If an unmarried son or daughter of a U.S. citizen gets married while waiting in F1, they shift to F3, which in many cases has a longer wait. The decision to marry for these families can have direct legal consequences on their immigration timeline. This is exactly the kind of detail that a qualified immigration attorney should walk you through before any major life decisions are made. And then there is F4, brothers and sisters of adult U.S. citizens. If you are following the numbers and wondering which category has the longest waits across the board, the answer is almost always F4. The annual visa supply for F4 is limited. The demand is enormous, and the per-country caps create a situation where nationals of high-demand countries are waiting 30 years or more for visa availability. For the Philippines, F4 final action dates in 2026 are reflecting priority dates from the early 1990s. For India and Mexico, the situation is similarly severe. Think about that reality for a moment. A U.S. citizen who petitioned for a sibling when that sibling was 30 years old may be waiting until that sibling is 60 before a visa number becomes available. By then, life circumstances have changed completely. Health situations, family situations, employment situations, and yet the legal process moves forward at the pace that the numerical system allows. This is not a failure of any single administration. It is the accumulated result of decades of high demand, limited supply, and a statutory framework that has not been comprehensively updated. Understanding this distinction, that the delays are systemic, not arbitrary, is important for managing expectations and making informed decisions. Let me bring this into focus with a realistic example. Consider a family. Let's call them the Delgado family. A U.S. citizen named Maria filed an I-130 petition for her married brother, Carlos, who lives abroad, back in 2004. Carlos was placed in the F4 category. His priority date was established at the time of filing. Now it's 2026. 22 years have passed. Carlos has watched his children grow up, graduate from school, and start their own lives. His priority date is approaching, but it is not yet current. Maria, now in her 60s, has maintained the petition through the years, ensuring USCIS has her current address, confirming the petition remains valid. When Carlos's date finally becomes current, he will need to go through the consular processing steps, completing Form DS-260, attending a medical examination, gathering decades of documentation, and attending an immigrant visa interview at the U.S. Embassy or consulate in his country. Any gaps in documentation, any status violations, any criminal history, any public charge concerns can complicate or derail the final steps after a 20-year wait. This is why preparation cannot wait until the priority date becomes current. The documentation work should be ongoing. The relationship with a qualified immigration attorney should be established well in advance, and the family should understand exactly what the consular process involves so there are no surprises at the finish line. However, this protection, the assurance that a pending petition will remain valid, may not be permanent in all circumstances. USCIS can revoke an approved I-130 in certain situations, including if the petitioner passes away without proper substitution steps, if the principal beneficiary commits a disqualifying act, or if the underlying relationship changes in a legally significant way. These are not common outcomes, but they are real risks that long-waiting families should understand. Now let's place all of this in its proper policy context, because understanding the system helps you navigate it. The family preference visa numbers are set by Congress under the Immigration and Nationality Act. The INA establishes the overall cap on employment and family-based green cards each year and sets the per-country limits that create the backlogs in high-demand countries. Congress has the authority to increase these numbers, eliminate per-country caps, or restructure the preference system entirely. Various legislative proposals to address family backlogs have been introduced over the years, but comprehensive immigration reform has not passed. In the current political environment in 2026, there is no imminent legislative resolution to family-based backlogs on the horizon. The Visa Bulletin will continue to reflect demand-driven wait times. The Department of State will continue to administer the preference system within the numerical limits Congress has set. USCIS will continue processing applications within its jurisdiction. What this means practically is that applicants and petitioners need to engage with the system as it is, not as they wish it were. Monitor the Visa Bulletin monthly, track priority date movement, stay in communication with qualified legal counsel. Do not make major life decisions, marriage, travel, employment changes, without understanding the immigration implications. This could affect you even if you are not in one of these specific visa categories. If you are an H-1B worker whose employer is considering sponsoring you for a green card through the employment-based categories, understanding the family preference backlog gives you context for how the overall numerical system operates and why employment-based retrogression happens as well. The systems are separate, but they share the same underlying architecture. So what do you actually do with all of this information? Here is a structured action plan for anyone in or connected to the family preference categories. Step 1. Locate your priority date and confirm it against the current Visa Bulletin. The State Department publishes the bulletin on the first business day of each month. Bookmark it. Read it every month. Understand which chart applies to your situation, dates for filing or final action dates, because USCIS announces monthly which chart to use for adjustment of status filings. Step 2. If you do not yet have an immigration attorney, get one now, not when your date becomes current. The documentation required for consular processing or adjustment of status is extensive, and the time to prepare is years before the process begins. An attorney can also flag potential issues early, things like periods of unlawful presence, prior immigration violations, or public charge considerations that could affect the final outcome. Step 3. Keep your petition alive. If you are a petitioner and your address has changed, update USCIS. If you are a beneficiary living abroad, maintain valid status in your home country and avoid actions that could trigger bars to admissibility. A long wait does not protect you from a disqualifying event that occurs during that wait. Step 4. Protect yourself from immigration fraud. Long waits create vulnerability. There are individuals and organizations that prey on waiting applicants by charging fees for services they cannot provide, claiming connections to USCIS officials, or selling fraudulent visa programs. USCIS does not have unofficial representatives. Notarios are not attorneys. If someone is promising to accelerate your wait time for a fee, that is a red flag. Step 5. Plan your life around realistic timelines, not optimistic ones. If you are in F4 from a high-demand country, make financial, professional, and family decisions based on a multi-decade timeline. If circumstances change, if you naturalize, if a petitioner passes away, if family relationships change, consult an attorney immediately to understand how those changes affect your position in the queue. Let's be direct about what is at stake here, because it is easy to get lost in dates and categories and lose sight of the human reality. Family-based immigration is not an abstract policy question. It is the mechanism through which millions of people maintain bonds with spouses, parents, children, and siblings across international borders. The delays in these categories affect family unity in the most concrete possible way. Spouses live apart. Parents age without their children nearby. Children grow up without the full presence of extended family. Employment stability is also on the line. For LPRs and F2A who are sponsoring spouses, uncertainty about timelines affects decisions about where to live, what jobs to take, and how to plan financially. For beneficiaries abroad, the wait affects career decisions, educational choices, and long-term planning in ways that compound over years. And for those near the end of a long wait, the stakes are highest. After 20 or 30 years, an error in the final stage, a missed document, a misunderstood question at a consular interview, an overlooked inadmissibility ground, can derail what has been a lifetime's wait. This is not the moment for shortcuts or assumptions. Understanding the system clearly, preparing thoroughly, and working with qualified professionals is not optional at this stage. It is the only responsible approach. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It's essential. If this breakdown was helpful to you, leave a comment below and tell me your visa category and country of chargeability. I read those comments. They help me understand what the community needs, and they help me focus future content where it matters most. If you know someone who is waiting in one of these family preference categories, share this video with them. Accurate information is one of the most valuable things you can give someone navigating this process. And if this kind of factual, policy-based analysis is what you come here for, hit that like button. It supports independent, credible immigration coverage. I'll see you in the next one.